Hi, everybody, and thank you for joining us for this webinar. My name is Mark Greenberg. I'm a senior fellow at Migration Policy Institute. Today, MPI is releasing a new report entitled Immigrant Families and Child Welfare Systems, Emerging Needs and Promising Policies. The report presents MPI work in conjunction with the American Public Human Services Association and supported by the W.T. Grant Foundation and the Annie E. Casey Foundation. In this webinar, I and my APHSA colleague, Ann Flagg, will provide an overview of the report, followed by remarks from a couple of state agency and county agency administrators, and we will then have time for questions. And I'm now attempting to move a slide. Great. Okay. So the audio from today's webinar will be available at the Migration Policy Institute website, www.migrationpolicy.org/events. If you have a problem accessing the webinar, you can contact us at events@migrationpolicy.org or by calling 202-266-1929. There is no voice Q&A when we go to a Q&A session, so to ask a question of the panelists, you can use the Q&A chat function on the right of the screen throughout the webinar, or you can write to events@migrationpolicy.org, or you can tweet @migrationpolicy or #MPIDiscuss. I'll initially turn to Ann Flagg, who is the director of the Center for Child and Family Wellbeing at APHSA, to talk both about why these issues are important to child welfare administrators and the approach that we took in this work. And then I'll come back in after that to talk in more detail about the report and the findings from our work. Ann.
Great. Thank you, Mark. It's a pleasure to present with you, Roberta and Tom, today. As Mark mentioned, I'm Ann Flagg with the American Public Human Services Association. For those of you unfamiliar with APHSA, we are a bipartisan nonprofit membership organization representing state and local health and human service agencies, their top-level leadership. Through our member network, APHSA seeks to influence modern policy and practices that support the health and well-being of all children and families that lead to stronger communities. The National Association of Public Child Welfare Administrators, an affinity group within APHSA, supports the collective policy and practice advances and learning agendas of child welfare administrators across the country. So why does this issue matter to APHSA and state and local child welfare agencies? As I'm sure Mark may elaborate on later, there are important considerations in terms of demographics. Since the 1970s, the number and share of children in the United States with a foreign-born parent have more than quadrupled. Nearly 90% of these children are U.S. citizens, and 25% have an unauthorized immigrant parent. While the research tells us that children of foreign-born parents are less likely to become involved with the child welfare system, child welfare agencies are working to develop capacities to better meet the needs of foreign-born and mixed-status families. Secondly, there have been significant developments in immigration policy and enforcement that have had important implications for state and local child welfare agencies, such as increased use of detention as opposed to alternative case management or other supervised community-based release options. This is creating a new dynamic on the ground for public child welfare systems, as well as fear and uncertainty in immigrant communities across the country. For context, I'll offer a very broad view of the child welfare system. The child welfare system is a continuum of services designed to promote the well-being of children by ensuring safety, achieving permanency in children's living situations, and strengthening families to successfully care for their children. Most families become involved with the child welfare system due to a report of suspected child abuse or neglect, sometimes called child maltreatment. Child welfare systems also may become involved in cases where parents are involved in criminal, or in this case, immigration enforcement. Child welfare agencies may also provide temporary foster care services, connect families to legal supports, or plug families into services that support health, nutrition, and child care needs to stabilize a child's care by a family member. Child welfare systems are complex, and their specific procedures vary widely by state. Likewise, each agency's depth of experience and sophistication of procedures in assisting immigrant families also varies widely. To better understand state and local child welfare systems, policies, and practices for working with immigrant families, Migration Policy Institute and APHSA reviewed relevant literature and conducted discussions with APHSA's National Association for Public Child Welfare Administrators, as well as interviews with administrators in 21 states and counties. We sought to better understand what organizational structures, policies, procedures, and partnerships are in place in states and counties across the country that enable child welfare agencies to meet the needs of immigrant families in their communities. Drawing from this work, this report describes a set of key policy issues for child welfare agencies and examples of promising agency approaches. I'll now turn it back to Mark to highlight some of the key recommendations.
Thanks very much, Anne. Just as some additional quick background, as Anne indicated, a child of immigrant parents can enter the state's child welfare system just like any other child based on a substantiated allegation of abuse or neglect. But there are potentially additional pathways for children of unauthorized parents if a parent is detained or deported. A threshold question might be how many children of immigrants are in foster care, how often is that due to deportation of a parent, and unfortunately this information isn't available. Under federal reporting requirements, states aren't required to collect this information, and since states need to serve all children regardless of status, states don't have reason to collect this information and will sometimes note that they don't want to collect information that they don't need that could also make families more fearful of engaging with them. The Obama administration had established a requirement that starting in 2019, states would need to report if detention or deportation was a condition at the time a child was removed from the home, but the federal agency has delayed implementation of this and other new data reporting requirements. One source of information we do have is from the Department of Homeland Security. This is not about child welfare involvement, but DHS is required to regularly report to Congress the numbers of parents removed from the country who state that they are parents of U.S. citizens. DHS reported 92,000 removals of parents in 2011, and as you can see looking at the table, it then fell to about 29,000 in 2016. The drop may be due, at least in part, to the Obama administration's narrowing of enforcement priorities and also instructing immigration officers to consider whether an individual was a primary caretaker, parent, or legal guardian when making decisions about arrest, release, and deportation. The numbers of removed parents continued to decline in 2017. We don't know yet what happened in 2018, but several factors could lead to more removals of parents over time. First, shortly after taking office, the Trump administration reset enforcement priorities to allow for removal of any unauthorized immigrant and eliminated provisions that gave consideration to whether the immigrant was a parent. Second, if the administration is successful in terminating temporary protected status designations for 6 countries and ending the Deferred Action for Childhood Arrivals program, it's estimated that parents of nearly 500,000 U.S. citizen children would need to choose between leaving the U.S. with their children, departing without their children, or staying in the U.S. and risking deportation. The terminations are currently being held up in the federal courts. Third, the increased numbers of parents apprehended at the southwest border could also have an impact. In 2012, 3% of apprehensions were members of family units. In the first 6 months of this fiscal year, that figure is now 52%. Such families could come to the attention of the state child welfare system if there's an allegation of abuse or neglect, or if parents are removed without or separated from their children. When parents and children are separated at the border, unauthorized children are sent to shelters funded by the Office of Refugee Resettlement, but if a parent is separated from a citizen child, that child may be sent to a state or local child welfare agency. The number of unaccompanied children apprehended at the border is also rising this year. Unaccompanied children are initially housed in the shelter system operated by the Office of Refugee Resettlement, where there are efforts to release them to a parent or relative or family friend. They'll only enter the state or local child welfare system if there's an allegation of abuse or neglect or that arrangement falls apart. As Anne indicated, in this project, we talked with 21 state and local administrators, and we focused on 9 issues. And the issues were, does the jurisdiction have a dedicated unit or specialized staff for addressing issues involving children of immigrants? What training is provided to agency staff on immigration-related issues? How does the jurisdiction address language access? Does the jurisdiction allow unauthorized or other non-citizen family members to be licensed caregivers? What are the jurisdiction's policies when a parent or potential caregiver is in a foreign country? Has the jurisdiction entered into a memorandum of understanding with Mexico or other nations for cases that cross national boundaries? Does the jurisdiction screen children and parents for potential eligibility for immigration benefits? Does the jurisdiction have policies concerning confidentiality and information sharing with immigration authorities? And does the jurisdiction have policies concerning parents in immigration detention? I'll talk about 3 of those issues in light of my limited time, but I encourage interested listeners to look to the full report where there's both more detail about these 3 and about those which I'm not touching on here. So, as to staffing and organizational structure, in our discussions, a number of jurisdictions did not have dedicated staffing. But among those who did, the 2 basic approaches that were described to us were having a dedicated office with immigration-related responsibilities and designating a dedicated liaison or resource person. For examples of this, New York City and Los Angeles County have dedicated offices whose primary role is to support their agencies on immigration-related issues and to provide resources to caseworkers who encounter questions relating to immigration. Several jurisdictions have these dedicated liaison or resource people who will typically function as a point of contact within the agency and provide resources on cases with an international or immigration component. Texas has regional immigration specialists to coordinate between caseworkers and attorneys to address immigration issues of non-citizen children. Texas also has border liaisons who specialize in cross-border cooperation with Mexican officials. Connecticut's Office of Multicultural Affairs and Immigration Practice combines some aspects of a liaison within that office, and the office itself works to expand the agency's capacity for working with families of diverse backgrounds more generally. A second issue to talk about here is screening for immigration benefits. Unauthorized immigrant children have 5 common options for potentially obtaining legal status. Special immigrant juvenile status for children who've been abused, neglected, or abandoned and can't be reunified with a parent. Self-petitioning under the Violence Against Women Act, U visas for crime victims, T visas for trafficking victims, and asylums. We found that jurisdictions often have procedures for screening and assisting potentially eligible minors for SIJ applications, but comprehensive screening for other immigration benefits was less common. Later in the webinar, Roberta will talk about Los Angeles County Special Immigration Status Unit. So I'll give some other examples here. New Jersey is notable because the state agency has a contract under which it refers every immigrant child client to Rutgers University Law School for screening, and Rutgers then handles cases through the entire process, including appeals. In New York City, each contracted foster care agency employs an immigration liaison who works to ensure that all non-citizen children and youth who come into care are screened for immigration benefits with subsequent referral and tracking. In Illinois, caseworkers ask children a set of questions to determine if they should be referred to the immigration liaison for more thorough assessment. And in Florida, there's a requirement that caseworkers refer all unauthorized immigrant children for immigration benefit screening once they have a U.S.-based permanency plan. One more point about screening. While jurisdictions range in the comprehensiveness of screening for children, we did not find examples of routine screening of parents for immigration benefits, even though they might benefit from that type of screening. A third area to discuss here is policies when parents are in immigration detention. A parent in detention might have an open child welfare case because the case was already open at the time of arrest, because the same facts that led to arrest could have led to opening a child welfare case, or because the child was without stable care after the detention of a parent. Detention and removal proceedings can make it challenging for parents to meet the conditions of case plans and court proceedings. Strict visitation rules, costly telephone calls, detention far from arrest locations can make it difficult for immigrant parents to communicate with lawyers, social workers, and family members, and parents may face difficulties complying with the reunification plan while in detention. In 2013, ICE issued a directive that was known then as the Parental Interest Directive. It was at that point called Facilitating Parental Interest in the Course of Civil Immigration Activities. In addition to addressing prosecutorial discretion, the directive had a number of important features, establishing ICE points of contact for parental rights, directing field office directors with some exceptions to detain parents near their children or family courts. It outlined ICE's role in facilitating family communications. It directed field office directors to facilitate parent involvement in ongoing child welfare or family law cases in person, by video, by phone. The directive was replaced by a revised one in 2017, which eliminated provisions concerning prosecutorial discretion and humanitarian parole, but left in place many of the other provisions described above. So when we talked in the course of our interviews, the child welfare officials we interviewed typically indicated either that they were unaware of the original or the revised ICE directive, or that the key directive provisions had not been incorporated into their guidance for caseworkers. San Diego County was a notable exception. San Diego's policy manual includes a step-by-step guide on how to find a person in ICE custody, points of contact for 3 California ICE field offices, a list of documentation ICE requires for visitation ordered by a dependency court, and relevant ICE visitation guidelines. The manual also provides helpful tips social workers should follow when working with asylum-seeking parents who are detained by ICE at the border. More broadly, California is notable for the Reuniting Immigrant Families Act, enacted in 2012, which aims to address barriers to reunification faced by families when a parent is detained or deported, among a number of other significant provisions. In this respect, it extends the period in which reunification can occur and makes it easier for children to be placed with a qualified caregiver regardless of their immigration status. It addresses reunification services during detention and provides for considering immigration-related barriers and extending periods of services. So, as indicated, these are just 3 of the 9 issues. You can turn to the report for a much fuller discussion of these and others, and I'll now turn to our other presenters for discussion of these issues as they play out at the state and county level. So, I'm initially going to turn to Tom Rawlings. Tom is the Director of the Division of Family and Children Services for the state of Georgia. We thank Tom very much for joining us. Thanks, Tom.
Glad to be here. Good afternoon, everybody. So just trying to get into what let me make sure I got the slides correct here. There were a couple of issue slides that we're doing. But essentially, what we have in Georgia, we're probably behind the eight ball a little bit in terms of being as advanced as Texas or California, but we certainly have a significant immigrant population here, and I would suggest that part of the let me forward this a second. Yeah. One of our biggest issues is not necessarily with undocumented children, but with children of undocumented parents who have been detained or deported. And so the issues we struggle with as a state are finding the parent who's been detained or deported. Of course, we try to use the ICE information line wherever we can. We oftentimes, when the parent's been deported, we work with the Mexican consulate to find, or the consulate of the country to find the person. And we also use such things as social media and talking to relatives. As you can imagine, arranging communication and visitation between the left-behind child and the deported or detained parent is an ongoing issue. Let's see. We have, the ability to use Skype. The ICE is supposed to be keeping the parents close, but frankly, that doesn't always happen. We certainly have an issue with visitation, especially if the parent's been deported, but anything we can do in terms of using WhatsApp or Skype or other types of technologies to maintain that contact, we try to do. As you can imagine, in situations where we need to serve legal process on the parent, that can be very difficult, especially when they've been deported. In Georgia, a father does not have legal rights unless he is married to the mother or has gone through the legitimation process. Under our laws, of course, those parents, those fathers, are still entitled to notice and an opportunity to be heard and to participate. But as you can imagine, once the father has been deported, the process of getting him legitimated, getting his rights recognized in the law can be even more complicated. We also have issues in terms of collecting child support from a parent who's been deported. So many times, as you can imagine, we have children who are in foster care, and you have, for example, a father or a mother who may be in the home country, having been deported, and who want to take care of their child. They want to support their child. But the process of getting our own child support services agency to work with those parents who are in another country and to make sure that they're processing those checks can be very difficult at times. Of course, whenever a child comes into foster care or whenever we're working with a family, we are required by federal and state law to really develop a case plan to either reunite the family or to, if the parents are not working that case plan or if they are found to be permanently unfit, to move towards some other permanency options such as adoption or placement with a relative. The biggest dilemmas we have here, of course, are how do you provide services for a parent who is in a foreign country after being deported. Oftentimes, of course, the deportation is actually the only issue, and so that's not, of course, considered abuse or neglect, and we can work with that. But we have had situations, of course, where a parent has been deported after committing a crime or after a situation of child abuse, and that is when we have to make a real determination regarding perhaps looking at the special immigrant juvenile status visa if it is not proper for the child to go back home. But I would say that in a significant number of our cases, we have the opportunity to reunite the child with the parents. Even though the child may be a U.S. citizen, we can make sure that we get the child a U.S. passport before they leave. We can make sure they get a passport of the home country, and then we can reunite the children with the parents back in the home country. That requires us to get home evaluations. We in Georgia often work with our sister agency in Mexico, DIF. I think it's the Departamento de Integral de Familias, and and so we get these socioeconomic evaluations. We have them translated. We work closely with the Mexican consulate, especially with the other consulates, protection departments when they have one, so that we can get those studies done, so that we can perhaps reunite those children and arrange for transportation back to the home country, and certainly make sure that the child has all the documentation needed to return to the U.S. If they choose to do so at a later age. The hardest part for me, from the agency standpoint, is that we have some, I would suggest, cultural, ethnic biases among some of our guardians ad litem and some of our court, and I guess perhaps among some of our own people, regarding the idea of sending a U.S. citizen child to a foreign country. The message that I continue to trumpet is that the national border should not certainly be a reason to keep a family apart. But we do have situations, of course, in which we have looked at the family's case, especially if there is a relative here with whom the child can stay permanently, then we may end up using the SIJS visa process and get our juvenile court judges to sign off on a finding that it is not appropriate for the child to return home at this time, but rather the child should qualify, especially the undocumented child, should qualify to stay here. And of course, in those majority of situations where the child is already a U.S. citizen, because the child's born here, if we can find a relative here, we try to go that route too. As you can imagine, and I think the report refers to this, too often the relatives are somewhat reluctant to come forward. They do not want to get, especially if they are undocumented themselves, they don't want to get in trouble. Unlike some states, we are really not able to use to license undocumented individuals as foster parents, and we aren't allowed to use state funds to pay for SIJS visas or subsidies for undocumented adults who may be caring for the child. But I would suggest that overall the report really focuses in well on the issues that we face, both with the undocumented child, but more so with the undocumented parent. And it is the issue for us of what we do with a U.S. citizen child or children who are here and whose parents were not documented and were returned to the home country. And what we do about the biases that come up in terms of the judges and some others who are hesitant to send the child back home and may instead want to find a relative here, especially when the child wants to go home and the parents want the child to come home with them. I think finally we have recently signed a memorandum of understanding with the Mexican consulate and are working on MOUs with the Northern Triangle countries as well, because we simply our staff are not. They have enough trouble figuring out how to place a child in another state, as you can imagine. And so when it comes to actually placing a child in another country, we sort of try to centralize that work and use our state office resources to help our counties. So that's kind of where we are in Georgia, and I'm sure in a few moments we can answer some questions.
Thanks very much, Tom. Just one quick comment before going on. In our looking at memoranda of understanding, there were a number of jurisdictions which had developed an MOU with Mexico. We actually did not locate any examples of MOUs with the Northern Triangle countries or really any country other than Mexico. There is, in our view, clearly a virtue in developing these, and so it will be a quite significant development if you're able to move forward on that. Let me now turn to Roberta Medina, Roberta is the Deputy Director of the Bureau of Specialized Response Services for the County of Los Angeles Department of Children and Family Services. And Roberta, thanks very much for joining us.
Thank you, everybody. As indicated, I'm from the Department of Children and Family Services from Los Angeles County. We have had a special immigrant status unit that was originally developed in 1991 after the passage of the initial law that allowed us to be able to secure special immigrant juvenile status for our youth. Initially, that was restricted to just youth that were in the foster care system where there was no reunification with either parent. That was subsequently modified in 2008, which broadened the definition of the child that was eligible for special immigrant juvenile status to include a child who had was not going to be reunified with just one parent. So that significantly increased the population of eligible children. The screening for eligible children in Los Angeles County is actually done as the child is coming into the welfare system. We have dependency investigators that are doing the initial investigation on the family and will include questions within their investigation to determine whether or not the child was born in the United States or not. We will secure the necessary birth certificates or additional documentation. Baptismal certificates are also used to be able to identify the child and the family. In most instances, our services are directed to the children and youth, not necessarily to the parents of the children, because they're in the process of either reunifying or attempting to reunify. In most instances, the children's case will be referred to our specialized unit. Our unit is comprised of a manager, a supervisor, 4 eligibility workers, and 3 clerical staff. Prior to 2010, we actually had CSWs that were carrying those cases, but unfortunately, due to increasing caseloads, we had to readjust the format of our program. In doing so, we have been able to screen those cases for not just SIJS, but we also use a complement of pro bono attorneys that will be assisting us to screen the cases for U visa, T visa, as well as VAWA applications and asylum. So those particular programs are also looked at in the screening process. Fortunately for us, we had a very good relationship with the original location of USCIS here in the Los Angeles area, and we actually had a prior process where we could walk into their agency, submit our applications directly, also had the interviews of the children done face-to-face during that process. In the recent changes in 2016, 2017, that process was then centralized, so we no longer have that ability to go direct. Prior to that, we had at least 3,000 applications for SIJS. We were one of the largest agencies that actually did submissions of SIJS applications within the state of California. That number has since increased to 22,000, which is inclusive of unaccompanied minors that are being referred by some of our agencies that have received legal services contracts with the Department of Social Services here in California to also represent those children and families. One of the things that I wanted to talk to is about some recent changes that we implemented into that unit, and that is making sure that all of our children who are also applying for SIJS are represented by an immigration attorney. This is something that we did not have to do in the past because the applications were processed very rapidly. Because we had a close relationship with USCIS, we were able to, if there was missing documentation, we were able to supplement that missing documentation by just taking over the paperwork or what have you. With the centralized process, you no longer have that ability. You no longer have the ability to have that face-to-face interview. So it made it very difficult to be able to pass paper from one state to the other in the centralized location in Texas. As a result, we looked at the applications that we were receiving, and we were receiving increased requests for additional evidence on some of our applications. During that process, we wanted to make sure that we were thoroughly reviewing all applications prior to submission, and we just recently as March 15th, engaged into a contract with one of our providers. We are very fortunate here in Los Angeles County in that there is a DACA network of pro bono attorneys and immigration attorneys throughout Los Angeles and California that are receiving additional funding from the state. 2 most prominent agencies that we have been working with over the years are Public Counsel and the Children's Law Center. The Children's Law Center are dependency attorneys that represent all of the children. They recently hired an immigration attorney to act as a liaison so that as we identify the children, then that attorney will then request the appointment of an immigration attorney from the contracted attorney locations, which the agency is called BETZEDEC. In addition to doing that, we were able to make sure that we provided additional training to all of our social workers within the agency regarding this new process. Again, the process does not affect the individual social workers because all of the work is being done and concentrated within the Special Immigrant Status Unit that we have. Many of you may be familiar with our prior manager, who was a national expert in this area, Cecilia Sacco, and I want to give her credit for all of the work she did within the 20 years that she was involved in the program. The program is now headed by a manager, Carlos Torres, and the program manager, who is Rodrigo Contreras, and together with the office of a newly created office at the county level, the Office of Immigrant Affairs, we have worked jointly with our county council to produce additional training for our social workers. We are actually also providing webinar support for some of our social workers as well as some of the other agencies involved with the immigrant families. The three top issues of training that we're looking at for all of the agencies involved with immigrant families is making sure that all families are aware of Know Your Rights. We have also provided additional training countywide on public charge and the impact of changes to public charge that were addressed in recent recommendations for legislative changes. In addition, we're also talking about the census and the value of the census that is coming up and making sure that our agencies and our families are aware of the importance of their involvement in that census for 2020. One of the things I do want to recommend to all agencies is that collaboration. This work cannot be done in isolation. There is too many children out there, there's too many families, and the policy issues are changing so rapidly that we highly recommend, again, if you have not already done so, establish memorandums of understanding with your Mexican consulate. We also have MOUs with the Guatemalan consulate, El Salvador, and Honduras. Unfortunately, with those three countries, they are in flux so quickly that they have a high turnover rate. So while we have those established agreements, the actual signed agreement is not in place because the administrations continue to turn over. However, the relationships continue to exist, and we've had very much success in working with these consulates to be able to obtain additional birth certificates, baptismal certificates, as well as assistance with obtaining passports for children once the children are placed in the additional countries. In addition to the Special Immigrant Status Unit, we also have a Hague unit that was created to be able to support the recovery of our children that were abducted. In California, many of our children that are in the child welfare system are often abducted by their parents, and they run for the border. The closest border is at San Diego border, and many of our children that are American-born citizens also become taken to those different locations. We work very closely with the State of Mexico as well to be able to make sure that we are doing repatriations of those American children found in any of their detention centers. We recently attended a meeting with them last month, and they indicated to us that at any point in time, any one of their centers in Tijuana or the border countries might have anywhere from 200 to 300 children in them, and of those children, many of those children are U.S.-born citizens. So we have agreements to be able to get across the border to be able to recover our children and bring them back to Los Angeles County. San Diego County is the liaison for most of that work. At this point in time, that process is changing, and they will then ask for liaisons in each of the California counties so that there will be a direct connection to the California counties. So we are now in the process of establishing memorandum of understanding with the U.S. consulates on the border to ensure that we can facilitate that process. Again, there is one other announcement that I wanted to make today is that in California at the state legislature, as recently as today, they are submitting a Assembly Bill, that's Assembly Bill 1324. It's entitled Foster Children and Immigration. In this particular document, the written measure would require the following. It would require CDSS to contract with nonprofit legal services organizations to provide legal services to children who are undocumented immigrants in the foster care system. And initially it was written to require social workers to include in their reports to the juvenile court information on the dependent child who is undocumented. Because of concerns regarding confidentiality of retaining that information and having that information available, an amendment was initiated today, which will also be heard at the Assembly today, regarding the following change. The bill is expected to be amended with the following language. 1, require CDS to expand an existing state program for providing services to undocumented persons. 2, require local child welfare agencies to notify a dependents, and again, that's a children's dependent attorney, within 72 hours of becoming aware that a minor or non-minor dependent is undocumented. By doing so, this gives us the opportunity, again, to implement the process that we have implemented here in Los Angeles County, which will be to notify the judges that the child is undocumented and to make a 317A appointment of an immigration attorney with that child as well. With that, I'd like to turn it back over to Mark and ask if there's any questions.
Thanks very much, Roberta. At this point, we are moving to the Q&A portion of our webinar. And as indicated at the beginning, but just to reiterate, lots of ways you can get us a question. There is no voice Q&A. To ask a question, you can use the Q&A chat function on the right of your screen. You can write to events@migrationpolicy.org, and you can tweet @migrationpolicy or #MPIDiscuss. And with that, let me move to several questions we've already gotten and welcome others. One question that we received is, do we have the number of children who've been placed in Child Protective Services custody due to deportation of one or both of their parents? The person asking was asking for a specific state, but the answer is no, we don't. And this is, as indicated in my earlier comments, this information is not collected in any kind of a central way. When we were doing interviews as part of this project, we did ask this question, and the most common response that we got were that the people who we were interviewing were not aware of instances or thought there had been very few. And we did hear that pretty consistent, or very consistently along the way. Certainly one would feel more confident if there was a regular structure for reporting the information, but that was something we heard pretty consistently. I should also indicate here that just in looking at the literature, the study that looked at this most closely was one that was actually back in 2011 by the Applied Research Center called Shattered Family Study. And in that study, they had estimated at that time that there were approximately 5,100 children in the child welfare system after the deportation of a parent. To emphasize, they weren't actually saying because of the deportation of a parent, but after the deportation of a parent. That's really the last instance where someone has tried to place a number on this. I should also indicate that in having these conversations and others, a couple of points that are frequently made are that in instances where one parent is deported, it may the other parent may still be here. It's also the case that because families will frequently have entered into safety plans, they may have made arrangements for what would happen if one or both parents was deported, that still leaves open the question of what happens over time with all of the pressures now facing the family arrangement that the child is in. So, the direct answer is we don't have a number. It would surely be better if we did. The numbers that we do have, again, from an older study, and then what we can see about persons who are removed who state that they are parents of citizen children, though to emphasize that's not to say that that means that those children are going into the child welfare system. It is telling us that a parent stating that they are a parent of a citizen child has been removed. So, we'll all try to give shorter answers on subsequent questions. The next question we got notes that Tom had mentioned that undocumented immigrants can't be foster parents in Georgia, and asked if we could explain, is this federal law or state law or something else? And why don't I invite both Tom to comment on it, and then Roberta. I know the policy is different in California, so if you both want to comment.
Let's go with California first, because this is probably the better way to do it. So.
Okay, so irrespective of the status of the relative caregiver, we do not ask that question. We do require that they meet the state requirements for licensing in all other areas, but that has not been a factor. When we are aware that there is a relative for one or both, may be a undocumented citizen, we also ask them, just like we do their families, to establish a plan in the event there is any difficulties. We ask them to make sure that we are aware of any future deportations. But one of the things that we encourage is if they're establishing legal guardianship, which would be, again, legal guardianship would be limited to the state of California, we ask them to consider the appointment of a co-guardian. And then oftentimes they may appoint another relative, a more distant relative, and or a child that may be born in the United States to take legal guardianship should they not be available for that particular child. But again, there is no restriction regarding immigration status to any of the services here in Los Angeles County.
And we place with relatives, but we have not gotten to the point of licensing undocumented individuals as foster parents, because we cannot, under state law, we cannot pay state benefits to any undocumented individual. We have a law kind of like Alabama had.
And let me just add a little bit on this. As Tom was just noting, there's a distinction between placing a child with a relative and the relative actually being licensed. And the importance of licensure is that it can bring financial assistance to help in addressing the cost of caring for the child. It can bring additional benefits that includes training and services and other supports. Federal law is silent on this one, and we found in talking to jurisdictions that there was a big range, that there were several where it was explicitly permissible for an unauthorized relative to become a licensed caregiver, some where it was permissible under limited circumstances or by waiver, some where it was impermissible, and some where state policy was just silent on the issue. And there is additional detail in the report, and the report also actually cites to work done by the American Bar Association, which has done a more detailed discussion of this issue with descriptions of policies in a bigger group of states. A next question. This is asked for Roberta, asking, can you talk more about the agreement to bring citizen children back to the U.S., how it came about, what should other border states be doing about this, and can you explain what happens for these children after their return to the U.S.? How long do they remain in care before placement with a family or foster parents?
Again, in most instances, again, this is under the Hague Convention. This would be considered in your policies under abducted child. So we have a designated county counsel that will follow up on any abductions of any children if it's determined that a child has been abducted and we have reason to believe that the child is in any other state, then we will issue a warrant to be able to return that child. The child will then be returned to the state of California. Additional efforts in reunification may be stayed pending the investigation as to find out what's going to happen on the criminal side of the case for the parent, and additional determinations will be made regarding the outcome of those particular additional hearings. The child will then be made a ward of the court, will remain a ward of the court. In most instances, these children are already a ward of the court, and then what we will do is we will make permanent arrangements for them, possibly with the relative, if there's any other additional relatives that are available as a first resource, and then looking at foster parents or alternative means to keep the child in care.
Thank you. Thank you. A next question is asked if the report talks about the effects of the MOU between ICE and ORR, of the information sharing MOU in longer stays at ORR shelters. And the answer there is no, that's actually not covered in the report. It is certainly a significant issue, and as the questioner notes, after ICE and ORR entered into this memorandum of understanding for information sharing, which did not prevent ICE from using this information for immigration enforcement, there was a notable increase in length of stay of children in shelters. But that's not covered in the report. What I should note about the relationship between unaccompanied children and state and local foster care systems, because this often does get confused. There's sometimes coverage saying children are being sent to foster care, and that's it's confusing because of some language that's used, but it's worth clarifying. What happens is children are initially go into the ORR shelter system. While they're there, there's this effort made to determine, do they have a parent, relative, or family friend? ORR does make use of something called transitional foster care, and what that involves is for younger children and pregnant and parenting children, in some circumstances, they will be placed with a licensed foster parent. They'll, while they are awaiting their placement with their parent, relative, or family friend, and while they are in transitional foster care, they'll essentially live with the foster parent, continue to receive services at the shelter. But it's not part of the state foster care system, though it is making use of licensed foster parents. Or also has something called long-term foster care, which again makes use of licensed foster parents in situations where children have no reasonable prospect of being placed with a sponsor in the foreseeable future. Again, it's with a licensed foster parent. There's a continuing relation with the shelter provider, but it's not part of the state foster care system. And as I mentioned at the beginning, the time that unaccompanied children could wind up in the state system is in circumstances where they've gone to a parent or a relative or a family friend, and the situation breaks down, or there are allegations of abuse or neglect. Let's see, and we have an additional question coming in. And actually, Roberta, this may be a question for you, but tell us if it is or isn't, and Tom, also feel free to answer, or Ann, feel free to answer on behalf of others in APHSA. The question is about addressing family concerns about participating in the census if not all members of the household are documented. And Roberta, you indicated that that's an issue coming up for you all.
Yes, and there's materials that may be made available that we can share at a later date. I can share them with you and make sure that everybody has them. Basically, what we are trying to do is in California, we are seeing after the recent changes in policy, many families being resistant to applying for services and resistant even applying for, a good example of this is the food program, the federal food program for children in the schools. And so what we are trying to do is to encourage them to be able to have their voices heard, to be accounted for in the official census coming up. Again, ensuring them that we're trying to do everything we can to identify all available households. In California, we do see a lot of families where there are multiple families in one apartment, and so that is really the targeted audience for all of us to make sure that we're accounting for everyone. It is a means to be able to get additional funding that may be available in the future at the state level.
Thank you. And Tom, Ann, anything that you'd want to add on that one? Okay. And if not, Ann, this question I believe is for you. And it is a genuine question that has come in. To what extent is the report going to make its way to relevant social services organizations in each state?
Ann, are you on mute?
Yes, Mark, could you repeat that question?
I can. To what extent is the report going to make its way to relevant social services organizations in each state?
Sure. So we will be distributing hard copies of the reports to child welfare administrators and or leaders at each state HHS agency responsible for child welfare services. We will be making the report available obviously through MPI networks as well as APHSA networks for download.
Thank you. And I should just add to that, when readers see the report, in each issue area in the report, we describe the issue, we give a bunch of examples of state and local policies or practices that appear relevant, and we make recommendations. And our hope is that with the framework that we've taken in this, that this will be quite useful for child welfare agencies as a kind of a checklist for them to consider in each area. Do we have an existing policy or practice? If not, do we need one? And to see examples of what others have done. And for people on the call who are not in the state or local agencies, but who have contact with them and work with them, we certainly hope that you will have an opportunity to share it with them and invite discussion around these issues.
And Mark, I don't know, can you hear me now?
Mm-hmm. Yes, we can.
Okay,
thanks.
good. So I can tell you that here in Georgia, we're currently still in the process of revising a lot of our policies. Our earlier policies really only addressed such things as SIJS and did not necessarily specifically address the deported parent in the full context. And so this is the kind of thing that we'll be using this report to help improve our policy as well.
Thank you, Tom. So at this point, we do have several additional questions we weren't able to get to, but we need to bring the webinar to the close. The slides and the audio from the webinar will be available at the MPI website, www.migrationpolicy.org/events. And in addition, for any reporters on the call who have further questions, you can call Michelle Middlestat at MPI 202-266-1910. We thank you very much for joining in. We would welcome additional comments or questions on the report as you have occasion to review it. And thanks very much, everybody.